Before we begin, I just want to provide a reminder about a few housekeeping rules for the meeting. First, please make sure your microphones are muted when you are not speaking. If you have any questions, please hold them. We'll have a period for questions. However, feel free to take advantage of the chat function to send questions in, and we will happily address them during the question and answer portion of the meeting. Now I'd like to take attendance for the board members present so we can make sure we have a quorum to proceed, which I believe we do. I'll call the names of board members, so please let me know if you are here. Just answer in the affirmative. Felisa Carter. Emily Gunston.
Here.
Sonia Wael or Antonia Nunez. Katia Semyonova.
Good morning, I'm here.
Good morning. And Ilana Suttenberg. Here. So I thought I saw Felisa was on. Was I mistaken?
Here, can you hear me?
Now I can hear you. Thank you very much. Okay, so there we have 5, and that's the number we need to reach a quorum and proceed with the meeting. So on the agenda today, with respect to old business, we have the continued review of the Clemency Board operating guidelines, and new business involves the update on community engagement and outreach efforts. The meeting today is scheduled to run an hour. If the meeting is to run long, I'll check with board members about their availability to continue the meeting. I know I have a hard stop at noon, but I'm hoping that we would start well ahead of noon today. So I'll now turn it over to our staff director to continue the review of the operating guidelines. We'll take questions on the operating guidelines after review. We just ask that you hold your questions to the end. And I do want to just say welcome to members of the public who are present today. And I see Professor Moyd is also with us. So welcome, Professor Moyd. So with that, turn it over to our staff director, Christina Sacco.
Good morning, everyone. Give me a moment to start sharing my screen, and just let me know if you're able to see it or if you'd like me to maximize the guidelines in any way. Okay. Can everyone see that?
Yes, I can see it.
Okay. Just make it bigger.
And I can actually read it now too.
Okay, great. So at our last meeting, we stopped towards the end of the guidelines. Right here. We had just begun the section on Appendix A and Appendix B. Let me change my views of all comments. Oh, it's already showing. Okay. So I would want to start with Appendix A, but I think because the substance of a lot of the questions and comments from the board are in Appendix B, I think we should start there. So just as a reminder of what Appendix B involved, is Appendix B, can everyone see the contents and the comments on the side as well? Just want to make sure it's not too small.
Can. Yeah, we can see them.
Great. So Appendix B are a number. I'm sorry.
You need to move it over more to the left. Sorry, I can't see half the comments. If you move over to the left.
Is that better?
Yeah, that's yes, that's better.
It may be too small now, I think, right? Well, let me know if you can't see the contents. I'm happy to shift them left and right for each comment view.
Let's just, is there anybody who can't read both the text and the comments? Okay, looks like we're ready.
Okay, great. So Appendix B were a list of factors that we had developed based on the Clemency Act about factors the board should consider when evaluating an application for a letter of recommendation. As you can see, most of the comments I've attempted to respond to so we can address them here. But the first comment came from Sonia Weil, who's not here, and her question was, her understanding was that we should be able to evaluate applications and wanting to allow some flexibility, but how can we ensure some consistency in these factors? And one of the things I think that's important to realize is we do have to comply with the Clemency Act, and we can certainly mirror the factors, as Ilana indicated in this comment, that are in the Office of the Pardon Attorney's Justice Manual. So for the convenience of the board and its review, I went ahead and added the factors that are in the Justice Manual here, and they're very general. So they, in the sense, they don't apply any type of a scoring criteria, but say these are the following factors and give a bit of a description of the factors involved. So just to give you a quick overview before we go into the meat of it all, these are factors from the DOJ's Justice Manual with respect to pardon applications. So there are a total of 5 factors, and then there are factors for commutation applications. And I tried to break these down into categories because it was more so in a paragraph in the Justice Manual. In our conversations with the DOJ Pardon Office, our understanding is, in addition to these factors, they also consider most of the same factors that are in the pardon category when considering for commutations, which makes sense. For instance, looking at post-conviction conduct, character, and reputation, that would also be something that you would consider in evaluating a commutation application. And then further down, these are the original factors that we had created. The first 6 are factors that are required by the Clemency Act. And the other factors are factors we pulled from different places. And, you know, I think there were discussions from the board of whether or not we should pull from IRA. These are just some factors that we looked at from other similar states that have a parole board, and then that had factors other than these in their parole board. And then here are some more IRA factors. With respect to this factor, which we pulled from a US code, that was removed because it seemed duplicative, but we'll go into all of this. But I just wanted to give you a quick overview of where all of this information came at. So this is an IRA factor. Again, this was pulled from a Georgia pardon parole factors, compassionate release. So hopefully that gives you a good overview of what's included here that warrants discussion. So with that, I want to open up to the floor of how does the board think about the addition of DOJ pardon factors and factors that are listed in the Clemency Act as being our basis for evaluations.
And I'm sorry, can you just scroll down to what you took from the DOJ website for commutations? I just couldn't see it that quickly.
Sure.
Thanks.
Sure. So with that, I just wanted to see what the board's thoughts are on these factors, which certainly can be sent. I mean, part of this is just to start the conversation to see what additional information you may need to reach a decision on these factors. Certainly, this will go back to the board for review, and we won't finalize all of this today because this warrants more of a discussion, but I think it makes sense to mirror considerations that the DOJ Pardon Office looks at, partly because that's who we're trying to send the letter of recommendation to, the president and the Office of the Pardon Attorney. And we certainly want to let them know that we've considered the same factors they did, in addition to factors required by the Clemency Act. Now, the additional IRA factors and so forth, I defer to those who have more familiarity with IRA and compassionate release. Those other jurisdictional factors do not need to be included at a minimum. I think the board needs to consider factors in DOJ pardons Justice Manual and the Clemency Act.
So you'd like feedback on that basic point first, right? Yeah. Is there feedback on that from the board? Opinions?
I do think that it makes sense to track some of the pardon attorneys, as my comment indicated, because that is kind of the, where these are going. Some of them obviously are more federal, like the death penalty one has no applicability really in the district. So there's some that probably could be, omitted from the local ones. But I do think that it makes sense to track a lot of the federal pardon attorney regulations generally.
I assume everyone's in agreement. Anyone opposed? Okay. Well, with that, we can start having a discussion about each. So the factors that are considered for pardon, first factor is post-conviction conduct, character, and reputation. And it looks to an individual's demonstrated ability to lead a responsible and productive life for a significant period after conviction or release from confinement is strong evidence of rehabilitation and worthiness for pardon. The background investigation customarily conducted by the FBI in pardon cases focuses on the petitioner's financial and employment stability, responsibility towards family, reputation in community, participation in community service, charitable or other meritorious activities, and if applicable, military record. The investigation also serves to verify the petitioner's responses in the pardon application. In assessing post-conviction accomplishments, each petitioner's life circumstances are considered in their totality. It may not be appropriate or realistic to expect extraordinary post-conviction achievements from individuals who are less fortunately situated in terms of cultural, education, and economic background. So, I mean, very broad, as you can tell, encompasses quite a lot. But I think that works to our advantage in considering applications because each individual's life, their story, their journey would be particularly different, and we would want to allow opportunity for considering the totality of factors in an individual's case. The only thing I would change here and I would recommend is the background investigation is customarily conducted by the FBI. While we would have that same option to us, because a background check of FBI through the FBI will be conducted here for the Clemency Board. Most of the background information would also be coming from CSOSA, BOP, and from the Superior Court of the District of Columbia. But I think we can say background investigation focuses on the petitioner's financial and employment stability and keep it more generally because we would be pulling from different sources for background information.
I think probably just the middle two sentences could be cut. Though I don't mean to dominate this conversation. I welcome anybody else chiming in as well. But just I think the FBI investigation generally, I actually don't know what they do in pardon cases, but in general, like for a security clearance, it's just much more voluminous than kind of a NPD, criminal record check or something. And so I don't know if that's what they do for a pardon case, but I can imagine that there would just be stuff in the investigation that the Clemency Board would not have access to. So I think it might just make sense to just completely cut those two sentences in the middle about the investigation and then just keep all the other soft factors in, and we could kind of consider whatever information in our files might be relevant to that. But once again, I don't mean to dominate this conversation.
I wonder if there's.
Go
ahead.
No, I was just going to say, did I highlight the right two sentences just to draw attention for everyone?
Yeah,
Yes.
I wonder if there's a different approach that we could take where we take the DOJ factors wholesale and say, here are the DOJ factors. We'll consider them as far as they are applicable. So that DOJ has them and we're not rewriting DOJ's own guidelines to the extent that DOJ cares that we're, or the Office of the Pardon Attorney to the extent that it's relevant to the office of the pardon attorney, that we've considered that, we could say that our factors are the DOJ factors insofar as they are relevant, and then we could kind of come up with our own DC factors as well, right? Additionally, 1, 2, 3, or whatever it is, but that way we have also our own, I don't want to say more expansive, but just like more tailored to the district.
I think
That
that's a
makes
great
sense.
idea.
Yep, I agree with that. I was actually thinking put the what's we're required under the Act first, not DOJ first, and then do a reference to the DOJ.
Sure.
Like DOJ could be an entire footnote that takes a whole page, or they could be like a separate appendix.
Maybe a catch-all or
Consider- Sorry, I talked over you.
I'm sorry, like maybe like I agree with what Katya said, like a catch-all or kind of overall kind of like a catch-all for in general, we will follow the DOJ guidelines, I guess factors as a guide, I don't know, a guideline. I don't know if that's the appropriate word, but kind of like we will put them into consideration. But yeah, I like what Katya said about more tailored to DC instead of just kind of wholesale. Just
I think that's a great idea. What do you all think of maybe doing it in the introductory paragraph and saying, you know, when evaluating applications, the Clemency Board tracks DOJ factors when they are so relevant to an application, in addition to the following factors listed below.
I would do it the following factors. I would just do it not even as an introductory, the sentence that you have, that initial sentence that you have, and then 1, DOJ factors insofar as they are applicable, see Appendix X for the DOJ factors, and then they're copied in their entirety. And then 2, or Patrick was saying make it 1, but the DC statutory, right? Then we go through the DC factors that are in the statute, and then we add other things.
If I could throw out one more option, I think it depends kind of what the letters that the Clemency Board sends the pardon attorney are going to look like. Like if it's going to be like, this person should get a pardon because 1, their post-conviction conduct, character, and reputation, 2, seriousness, et cetera, and kind of goes through the factors and kind of really like says like, here's why they meet all of these factors and therefore should be granted a pardon, then it might make sense to just kind of track those and have the letter and the format track those, because then the pardon attorney could look at each of those individually. I think it might make sense to actually keep these here, but then to kind of add on to each one anything that might be more district specific, like kind of underneath each heading. So like kind of heading post-conviction conduct, character, and reputation, and anything that is not encompassed here could kind of be like, in addition to the DOJ factors, the Clemency Board shall also consider, I don't know, whatever it might be. So it really just kind of depends on how we kind of want the end product to look. And I think kind of almost a worksheet is not the right word, but like kind of how it should be filled out for presentation to the pardon attorney.
Any board members on which particular format you prefer?
Yeah, I would like the DC stuff to go first.
Anyone else?
I would, on number 2, I would write insofar as that they are applicable. I guess I just disagree with the ability to change their factors. I think that there are going to be places where the district wants to disagree with the DOJ or just work separately and yet consider those factors because they're relevant to the final decision maker. And so I'd be hesitant to change their language in case it undermines the application at the DOJ level, because we have changed it, it has somehow undermined the application, and therefore we would be considering both. We would consider those insofar as they're applicable plus our own.
Okay. So with that in mind, here are our factors. So let's just, the way it would start with our factors are an applicant's criminal and civil record, that an applicant has demonstrated he or she is rehabilitated and no longer a present danger to the community. An applicant has described how a pardon or commutation would help the applicant achieve his or her goals and contribute to the community. Applicant is terminally ill for clemency board purposes. Applicant is elderly for clemency board purposes, and was the applicant's relevant offense for conviction decriminalized, or have sentencing practices changed, for example, as a result of the move from determined sentencing, the closure of a DC parole board, or the use of DC volunteer sentencing guidelines, such as an individual convicted under current practices would have received a less harsh sentence. So all of these are factors that are required by us to consider under the Clemency Act. This one is under compassionate release, but is also part of our priorities under the Clemency Act. And this as well. So for right now, these are our minimum factors. The following were just additional ones. Wanted the board to consider, and then we can certainly add maybe a number 7 that says the DOJ factors, and so where they are relevant with respect to an application we receive. We didn't know if we wanted to, add additional factors beyond this. My recommendation is to just start with what we're required to do under the Clemency Act and where are the DOJ factors.
Yeah, I agree with that. If you can move the DOJ stuff to number 7, I think that works. With that preface that Katya mentioned about, to the extent that these are applicable.
I think it's called the Justice Amendment. I will cite it formally.
And are these factors in any order or priority, or are they just kind of whatever might be?
Not, there is no order. Are you referring to the DOJ?
The DC, no, the DC ones. Sorry, like, is it like number, like, is kind of the ordering of them within it, does it indicate a priority level within consideration? And if not, maybe we should, either way, we should just say that.
Not in accordance to the statute. However, we do have a modifying paragraph here, but we'll get to that later about what else we want to put, that there is no order of preference about the evaluations. Cite to the manual. And I think the modifier was in so, what was it, in so that they are relevant to an application?
Insofar, I thought it was to the extent they are relevant.
Applicable. I like applicable better.
Yep, good.
Okay. So with that, I will remove the following factors, which I've enumerated here because they're all encapsulated under 7. And then this is what it would start out.
And just the formatting of number 6, all the others start with applicant, so maybe that one, applicant's relevant, you know.
How does the sentencing practices change? I believe these edits were by Katya. Katya, does that suffice? Because before we had it very simply that the sentencing scheme for the offense for which he or she was convicted changed to provide for less severe penalties. And Katya, Elon, I don't know if you want to expound on why we wanted to break it down between the determinant sentencing, the closure of the parole board, and the use of DC volunteer sentencing guidelines, and how that could lead to an offense being decriminalized or receive a
I
less.
think the way that it's phrased now is actually mostly responsive to my concerns. I think it was like, I'm just kind of thinking prospectively as criminal code reform takes shape and like basically every sentence is reshaped, then that would make every single person eligible. And I don't think that's what this was trying to get. I think it was like, you know, not just like, has your sentencing scheme changed? Because literally every sentencing scheme is about to change, but rather kind of like, would you have been convicted? Like, would your sentence look the same? And I think that the current language actually encapsulates that because it's talking about an individual convicted under current practice. So I think that that's actually, I think it's responsive, but let me know if anybody disagrees. Is there language also in the bottom that I think there might be, if you could just scroll down, Christina, that says that basically none of these is dispositive, but it's kind of like in the totality and kind of what might be applicable to this defendant or something like that? I mean, you're probably in there.
So these are from our regulations that we follow that board need not score nor award or deduct points for any particular element of an application. The board may disregard any factor that is not relevant or does not apply to a particular applicant. So for instance, if a person is not elderly, one of the factors we look at is whether they're elderly. The board may come to different determinations on applications by some measure appear similar, so that we could add in, more about the totality of an application. The board may also evaluate applications for letters of recommendation based on criteria, including the standards outlined in the DOJ Justice Manual, DOJ policies and priorities, and other clemency-related initiatives of the President of the United States, the Mayor of the District of Columbia, and other interested institutions.
Yeah, I think it might just be helpful to say like no factor is necessarily dispositive on its own, but like should be considered as a part of the total application process. I don't know, or something like the totality, something like that, just to clarify.
Does that help?
Sure.
Should be no factor,
Yeah.
or no one, or maybe no one factor.
Mm-hmm.
I read that other part a couple of times. Sorry, I was so slow. I think it's fine. And the
And maybe no one
decriminalized.
Maybe just no one factor is necessarily dispositive on its own, because you could have a situation where one factor is just so powerful. But
I agree with that.
Okay. All right. So going back to the factors, I'm assuming, pulling these additional factors from IRA and other jurisdictions, in many ways, I think may be duplicative, considering we are looking at one, how the DOJ factors are viewed. They're pretty broad, and they include, all of this information, like connection to the community and so forth. So is the board in agreement to remove these additional factors that are pulled from IRA and other states, or are there particular factors you believe should be added in that are not here? So I can take them individually as we go. So 8 is the applicant substantially complied with the rules of the institution to which the defendant has been confined. And I think one of the factors under DOJ was post-conviction reputation. So I think that is sort of covered. I don't entirely think that that's necessary to have that fleshed out here. Just wanted thoughts.
I think it might be helpful to spell out a few of the most relevant ones from the DOJ. I don't think it's necessarily duplicative to kind of say like DOJ could have kind of anything else, but I do think that I think it's helpful to spell out a few of the kind of most relevant ones here. I think that one is an appropriate one to keep in.
From the list that we have above?
So below.
That has, I think Christina was suggesting deleting like 8, 9, 10, 11. Is that right?
Right, 8 through 13.
Yeah, I think it's appropriate to keep them in as kind of express factors to consider.
Okay.
Why are we duplicating?
I mean, I think
Sorry, but it is just pulling out the ones that are in 7 and making it and repeating the ones from 7.
I mean, I think if we want to set forth all of those, but I think also the commutation factors from DOJ are a little bit looser. Like we were looking at the pardon factors, and I think the commutation factors are not necessarily as clearly set out in the Justice Manual. And so I think, yeah, I can look back at that though.
I don't feel like we need to do that because it's referenced in 7, in the current number 7, and we say pardon and commutations. Can you go down again?
Sure. I want to caution against adding more factors that we're not legally required to add. Partly because of our compliance with the DOJ factors and the Clemency Act puts us in compliance with the law. I think that suffices for the board. Adding these factors when they're already mentioned, I think would be unnecessary in many ways, duplicative, but I defer to the board.
Can you go back to the kind of those general statements that were either at the top or the bottom? I don't remember where they are now.
Oh, I deleted them, but I can pull them up. They're right here in this one.
No, I don't think you deleted them. I think you left. No, not DOJ. The ones that were, we don't have to look at everything. We can.
Oh, the evaluation process.
Let's just see if this section gives us freedom. So we have the act, then we have the DOJ pardon attorney manual stuff, and then we still have discretion. I just want to make sure the board maintains discretion. And does this give us enough leeway to take, then we could take those other things out if we wanted to, if they're already in the DOJ process.
There's also this catch-all here that allows the board leeway and discretion, additional factors.
So the problem with the Justice Manual is that for the pardon attorney, it's like a really concrete set of factors, but for commutation, it's just not. And it's like really fuzzy for commutation. And I think it just needs a bit more guidance. My recommendation with the Justice Manual.
I think partly the issue with that is that's what the Justice Manual conveys to the public as well, right? And so if we're trying to mirror that and create more of guidance on something we do not have, even from the Department of Justice Office of the Pardon Attorney, it would be creating standards that don't exist for OPA on ourselves.
So what,
So, Lana, I want to ask you a question. Do you think by keeping them in, it gives us a clearer presentation of our reasoning around commutations? If say that we were to support
yes,
recommend a commutation, leaving these in would somehow support that?
I do think so, but I have no like inner insights into pardon attorneys thinking on this at all. So just to be clear on that. But I do think that more specific factors and kind of why a person meets these specific factors could be a useful way to develop a position and a recommendation. I mean, I think that the standards for pardon are just like very clear in the justice manual and like what should be considered. They're really factors that I think are very similar in a lot of ways to what we're working on. And for commutation, it's just different. And maybe it could just be a broad statement. I mean, I think that there's just, yeah, I don't know. I'm just talking.
So what the reason I asked about those, do we have these general things that the board may consider other things? I mean, we can still use these criteria if we decide, hey, look at, you know, the nature of the offense is so, and the defendant's role is, you know, so minor, blah, 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 blah. I mean, we could still use that. We still have enough space in our regulations that allow us to consider that. And it doesn't run afoul of, you know, adding more detail to the commutation thing doesn't hurt the commutation, I don't think, or the request for commutation.
I mean, I think we've kind of spelled out other factors, like basically like are they elderly, or you know, which I think is important to consider, obviously, but it kind of seems like there's a lot of weight on that and not so much on maybe some of these other things that might be relevant to the consideration. And I think it might make sense to just kind of include all of the factors that would be weighing into the thinking here. I mean, unless we want to just kind of cut and paste what the pardon attorney says for commutations. But I think there's just less guidance when it comes to commutations than to pardons.
I think the difference with the elderly factor is that's actually required by the Clemency Act. The rest of the factors after 7 are not required by the Clemency Act, but they are required by the DOJ factors. They're all encompassing. And even the DOJ factors are quite broad. They're very broad statements, like a person's reputation, conviction, character, and their involvement in the community. That goes into a lot of factors that are spelled out here. I think ultimately all that information will be conveyed when we retrieve records on an applicant. And I think having it more broadly is important because different factors may come up for one applicant and not necessarily for another. Let's say, for instance, you know, I'm looking at these factors. Let's say an individual doesn't have any child welfare system factors. Why spell that out there when you can speak to a person's background generally, your background, your involvement in the community, your reputation, your character? Those can pull generally into those factors. And I think it's hard to put a rule that can apply to an individual's case that is so unique.
Sure. But I think in the Clemency Act, I mean, the only reference to terminally ill or elderly is just give special consideration to applicants who are terminally ill or elderly. Like consideration of what, right? Like that's kind of where we are now. Like we're talking about the operating guidelines and what are we considering? And we're just supposed to give them special consideration, but kind of consideration of what? And I think that's kind of what we're navigating here, and not just like that they are terminally ill or elderly, but like what does that get them? And that's kind of what the other factors I think would apply as well.
I'd really love to hear from other board members about their opinion about this part of the conversation.
This is Felisa speaking generally. I'd rather us have more leeway than to confine ourselves to any strict definition of there's something that will bind us to some factors on the paper. I want us to have more leeway than less, and I'm always siding on the giving us more room to operate, or in the benefit of the people of DC, than to just go with just what the DOJ says. Or, I mean, they can have, like, of course they'll have influence because they are the final decision makers, but I rather give DC, us, the board, more leeway than less. So I'm always for giving the board more room to move, wiggle room than less.
I agree with that. And I think that it becomes really hard to say what it is that about being elderly equals a commutation or a pardon. And that the flexibility, I think, is important. And we have the sort of the catch-all compelling reasons, and we have these considerations, which are points of consideration. And I worry that listing things like institutional compliance overly focuses on that and then doesn't allow for a more expansive consideration of the whole individual, and may be too myopically focused on a single event at a prison where they had little opportunity where there's just little opportunity to offer all the mitigation.
Christina, would you scroll up to just the first few again? Do we want to include information about the victim? Because I think that is important, and that was one of the ones that I think we're talking about cutting.
If I'm not mistaken, I believe that is also in the DOJ factors. Correct.
I don't know if it's in. Let's see, not sure. So it's a little complicated in the DOJ factors because the prosecuting component, that's us, reaches out to the victim when we're before the pardon attorney, and that will not be happening within the clemency board. So I think that it's kind of, I think, I can double check, but I think the victim's views are presented in the context from the U.S. attorney or the prosecuting component. And it'll just be different in the clemency board.
So it hasn't been fleshed out in particular here. I think it says victim impact may also be a relevant consideration. I mean, it's very broad, and I think this so points to what the DOJ also was going for, a more broad approach. I think that given that that is here, and we do consider it's part of our hearing procedures to allow for victim statements, that we would reach out to victims, and whether it be a victim representative who submitted a statement or would do it at a hearing. We also allow character witnesses. So I think defer to the board here, but I think even that one statement is enough to say that that was considered. It is part of our hearing procedures in detail.
Sorry, this is my last point, and then I don't mean to keep interrupting other people or talking too much. I'm sorry. I do think that it should be explicitly said that the views of the victim, like I think it should be an explicit factor for the board to consider the views of the victim as it's kind of written earlier. I think that just really clarifies it, and I think victims might feel more empowered to speak if they are expressly included as an enumerated factor that the board's going to listen to. Otherwise, I think it's like a little bit confusing as to what's the purpose of them coming to a hearing at all if it's not going to be considered by the board.
Other comments from board members on that topic around including a criteria around victims?
Is that in the statute?
It is not in the clemency statute, I believe. It's in the statute.
So why isn't it sufficient with reference to referring to the DOJ?
Well, I think the DOJ one, it just kind of says the views of the prosecuting attorney shall include kind of any views from the victim. That's how I read the DOJ manual. And I do think it's different here. But I do also think that that kind of ensures that victims feel that their voices are being heard and considered by the board.
And the makeup of the board, I would just mention, also includes someone who represents the victims.
One day.
One day, very soon, we hope.
Yeah.
Although that's for others to decide. We hope very soon.
What if it's broader and it says, statements of any parties, like evidence statements of any parties, including victims, so that it's not, I understand the concern of having that voice heard, but if it is just sort of singled out in a single factor rather than saying all voices should be heard and considered.
So here we have it as any statement provided orally in writing by a victim of the offense for which the applicant seeking clemency or by a family member of the victim. If the victim is deceased, I think we could just put it as a family, instead of family member, put a victim representative. Any statement by a character witness or victim or victim representative.
At least,
We could do that and keep it broad.
Yeah, I think language like that would be appropriate.
Anyone opposed?
Sorry, I think I just couldn't quite understand how you, maybe if you write it out, I'll just be able to see it.
Happy to do
yeah,
it.
I'm in the same position.
Sure. Bye.
What if it's any statements provided orally or in writing by witnesses for the applicant or witnesses for the applicant, a victim or a victim representative if the victim is deceased?
I think the other thing to put here is I would remove the if the victim's deceased and just put or a victim representative so that there might be instances where a victim does not want to themselves come forward, that they should still have an opportunity to do so. So something along the lines of this.
And I think, yeah, you want to make that or a victim's representative, not for.
Oh, it's crossed out. You better say that. Space.
Thank you. Any more discussion on this factor? And Christine, I just want to confirm that this is one of the 14 was one that you thought should remain. It was not one you were. Is that correct?
This is to, I think from what I understand, the discussion was, should we keep 8 through 13? But if we're keeping 12, I can adjust it as we go. I just need confirmation from the board of how we would like to proceed. Certainly something that we could also vote on, and then I can, if we want to do a broad approach, do we want to enumerate all of these and keep everything through 7 and number 11 and 13?
I think 12 is a good one too. I don't know, is that duplicative? That seems useful.
I think all of that goes into rehabilitation and no longer a present danger.
This is kind of typographical when we're talking about kind of witnesses, parentheses, and then can we do victims like parentheses too? Because there could be multiple victims.
Sure. Is that what you're referring to, Ilana?
Yes.
And just take the A before victims representative.
I think we could keep in victims of the offense for which the applicant is seeking clemency.
Okay, so are there other comments on these so far up to 13? It sounds like we have some agreement. I mean, this is all going to be voted on at the end, but we're trying to get it as close to that today as we can. Any other comments on these so far? Okay, I just want to do a time check with board members. It's now 10:56. We have 4 minutes left in the scheduled meeting. Is there anyone who's not able to stay for an additional 30 minutes? Okay, hearing none, so why don't we plan that we'll go until 12:30, Christina, if we need to.
Sounds good.
Thank you.
Before I get into Appendix A, I just wanted to take this opportunity, Patrick, to see if there are any public comments on these, because we didn't have time for that last week, and I want to make sure we get those so we can address them and then move on to Appendix A.
Thanks very much. Let's go ahead and do that.
Hello, everybody. This is Professor Moyd, and I just have one comment. I'm not sure if I saw it anywhere. In looking at the factors to be considered for pardon applications, one of the factors that I thought about is substantial compliance with parole and supervised release conditions. And I saw in the commutation section compliance with institutional rules and, institutional compliance, but I didn't see anything that referenced when a person is out in the community, substantial compliance with parole and supervised release. And I only mention that because I know that, just being able to navigate that process is quite an accomplishment, and I think it should be considered as a factor.
Thank you, Professor Moyne. So, would you, in your opinion, Professor White, wouldn't you agree that that would go into factor number 2? Applicant has demonstrated that she's rehabilitated and no longer a present danger to the community. Just to keep it more broadly, because there are lots of rules in it other than parole and supervised release that an applicant would have to uh, adhere to in order to demonstrate rehabilitation.
Yes, I do think that that would be included generally, but I heard mentioning reaching out to CSOSA, and I know in many cases they, have a letter of successful completion that they will send out. And I just think that if the board is communicating with CISO, so that that might be one of the specific things that they ask for, not just generally how was the person doing on supervision or how did they do, but that certificate of successful compliance, again, is a big achievement.
Thank you, Professor Moyne. Other board members?
To the extent we're incorporating the DOJ factors, I do think that this is one of the DOJ factors that in the pardon section, the demonstrated ability to lead a responsible and productive life for a significant period after conviction or release from confinement. So I think that it would probably be subsumed in there, but let me know if you disagree.
Professor Moyne, I think that question was directed at you.
Yes, I don't disagree. I agree that it is certainly encompassed in that. Um, I just think that, as the board goes through the process of looking at specific documents, that that's something that you might want to specifically ask for.
Christina, is there anything in our conversations with some of our partner agencies and people who are supplying documentation to ask for specific things?
Certainly, with CISO, so we do get their progress reviews and the pre-sentencing reports, so we would get all that information. So it certainly is considered. It's, I think, ultimately, spelling it out. We're going back to that same conversation we're having with all the other factors, is that is it better for us to be more broad, where we're all encompassing, rather than identifying particular factors here, which creates more of a line item for us to look at.
Thank you. I am definitely in the camp of leaving it broader so that the board can consider the factors that are brought before them and that they think are important. Are there other public comments?
We have one more public member who I can't identify by name, but sir, you identified yourself at the beginning of the call. Do you have a question or a comment?
No, thank you. Interesting.
Thank you. All right, no more public members to address Patrick.
Okay, great. So let's go to Appendix A.
So Appendix A are factors that the staff director would look at to determine completeness and eligibility of an application. And it's really just a sort of checklist for the staff director to make sure we have all the necessary documentation and that the applicant is eligible to proceed towards the next step, which would be retrieval of documents and evaluation of the application. So the first question goes to completeness of the application. Is contact information fully described? Is there secondary contact? Did the applicant answer all eligibility questions that are set forth by the code, which we'll go into a little bit later? Has the applicant provided a response to the essay question? Is the application signed? Is all of the information legible? And then if there's any follow-up that's needed, and if these questions, that we would say that this section is complete with respect to the application. Then we'd go into, release information, BOP release. Is it signed? Is the clemency board listed as a recipient? Did they write in the required statement about the clemency board, which is detailed in the instruction page of the application? Did they initial in these sections? Is it complete? And we would detail if there's any follow-up. Same thing with the ROI form for CSOs, the MPD, and the DC Superior Court. Is the release signed? Any follow-up needed? It's a very simple form. And there's also a medical release information for CSOSA. And this would only apply is if we would seek their current clemency application if they've applied to the GOJ prior to coming to the clemency board, that we could retrieve that information through a ROI release that the DOJ, Office of the Pardon Attorney, has given us. So all of this information would help determine whether or not we have all the required documents to move forward to retrieve background information on an applicant. Any questions or concerns thus far? Sonia's not here today, but her question isn't the first question we need to ask whether the applicant has filed an application with the DOJ, otherwise they're not eligible for a letter of recommendation from us. So again, just to clarify, that was our initial process, but that process has been foregone given the public comments we received when we drafted our regulations. So now an individual, according to our regulations, an individual can apply to the clemency board without having to go to the DOJ first, or submit an application for clemency with the DOJ first. So that is no longer a prerequisite to receive the letter of recommendation from the board. So if there are no questions here, I can move into the next section. I'll give a moment to hear from folks. Okay. The next section goes into eligibility. And this goes into purely the Clemency Act that was passed by council, which is what created the Clemency Board. And the idea is if any of the questions here, 1 through 4 is a no, they would be deemed ineligible. 5 through 9, yes, they would be deemed ineligible. So let's start with 1 through 4, that if it's a no, they're ineligible. Is the applicant a person who has been convicted of violating a DC law or regulation and is seeking a pardon or commutation for that conviction? Obviously, if they're not, then they would be ineligible because we need to have, it has to concern DC law or regulation that they're seeking a pardon or commutation for. And this applies only to pardons according to the Clemency Act. There's a 5-year waiting period from an applicant's date of release, or in case of no imprisonment, there's a 5-year waiting period from the applicant's date of conviction. So we need to check that. If they have not exhausted those 5 years, or it's not at 5 years, they would be ineligible. So the third question goes into the exhaustion of remedies question. Has the applicant exhausted all judicial and administrative relief available to challenge their conviction or sentence, meaning he or she does not have other judicial or administrative ways of challenging his or her sentence or conviction? This can include relief such as a motion for compassionate relief, relief under IRA, or challenges to a conviction on the basis of innocence or through an appeal or other court proceedings. If they do have additional administrative opportunities of relief, they would be ineligible. So one of the things we'll ask is there an appeal motion currently pending before the court? Is there a motion for compassionate release pending? Is there a motion under the Incarceration Reduction Act pending? And then we kind of break down what that entails. IRA allows a person who's committed a crime before the age of 25 or who has served a minimum of 15 years to apply to the DC Superior Court to have their sentence reviewed. And I think we stop at 4. It's 4 applies to pardons. Has the applicant been convicted of any criminal offense that is relevant to the conviction for which the applicant seeks? So are there any tangentially related criminal offenses? So any questions with respect to 1 through 4? Okay. 5 asks for pardon applications only. Has the applicant been subject to any pending criminal charge that is relevant to their conviction? That the applicant seeks clemency, and then has the applicant been a party to a past or pending civil case that is relevant to the conviction for which the applicant seeks clemency? So what I think here, Sonia posed a question between 6 or 7, and the difference between 6 or 7 is, has the applicant been a party to a past or pending civil case that is relevant to a conviction? See, has the applicant been a party to a past or pending civil case that is relevant to the conviction? We need to look at the statute. Is the applicant a party to a past? So this seems to be more, this deals with currently. Is the applicant a party to a pending civil case, or has the applicant been a party to a civil case? I think this is what needs to be changed. So the questions are not subject to any pending criminal charge that is relevant to conviction, not a party to a past or civil case that is relevant to a conviction. So these are pulled from the board. 1 asks that they're not subject to a pending criminal charge, and 1 asks they've not been a party to a past or pending civil case. So while it's not entirely clear, it is required by the Clemency Act. I didn't know if board members had problems with phrasing it this way.
I don't understand the difference, really. I'm a non-lawyer, so I don't really get it.
So we can start with the criminal offense. Not have been convicted of any criminal offense that is relevant to the conviction for which the applicant seeks. And then not be subject to any pending criminal charges. So 1 is a conviction, 1 is pending criminal charges. So that's, go back here. The applicant has been convicted of any criminal offense, and the applicant has been subject to a pending criminal charge. So that those are the 2 differences here.
So, did it happen in the past, or is it still possible now? I get that.
Exactly. Okay.
For
And
number
then
4,
that's
I think it's just convicted of any other criminal offense. I think that's what the statute says too. Because obviously they're convicted of this one.
Any other? Okay. And the 1 is a pending criminal charge, though. And then here, not be a party to a past or pending civil case. So applicant has the applicant been a party to a past or pending civil case? I guess these two.
I just cut and paste those few things from the statute in there, and it might make sense to just like track the wording exactly. For number 5, maybe present tense, is the applicant subject to any pending? And I'm sorry, I think in other ways that you did track the statute exactly. I didn't mean to over correct you.
Just the no part of things. So you want me to track this? I think it does track it exactly.
I know. I'm sorry, it does. I did just seen that one. You're right. It does. Good job. I think that there's just an extra one. I think that's the confusion. I think 7 seems to be a kind of extra one.
Duplicative one.
Yeah. Yeah. Party to past or pending. So
is the party as the applicant. Is the applicant a party or past? Okay. And then, does that seem more clear to everyone about the questions? Is the applicant a party to pending civil is relevant? And then 7 just asks, is there any other post-trial motion pending in the applicant's underlying criminal case relevant to the conviction for which the applicant seeks? If so, the board must determine if it falls under the exhaustion of remedy requirement. So we would just ask for that information from an applicant.
is one of the things that we're getting from the board just the docket in their criminal case?
So we would get that, yes.
Okay, great.
Any questions thus far on the completeness and eligibility questions? And then lastly here, this is just a checklist of once we've sent out the ROIs and the various requests for information from from BOP, CSOSA, and MPD, that we would just check it off that we received them, and that would ultimately make the application complete. And it's from this point of completion that the board has 6 months to review an application. And so I think, Ilana, I wanted to bring up your question for discussion here. One of the documents that we'll be receiving is the pre-sentence report. And I think Katya also alluded to this as well, that in general, applicants are not given access to their pre-sentence report. Is that correct?
That's when they're in the BOP.
So it would be for individuals who would be in BOP custody that it would apply to.
Yes, so I mean, it may be difficult for other people to get it if it's been a long time, if their lawyer doesn't have it anymore, or if they can't reach their lawyer.
And so one of the things we would have to flag is that that we'd have to handle one of the things we added was handling instructions with respect to documents that we'd receive with various agencies. So if CSOSA does not share that information with an applicant, that we would also not share that with an application with an applicant unless we receive the authority to do so.
I think there's also just kind of a question generally about pretrial sentence reports just being, they have a fair amount of, sorry, pre-sentence reports have a lot of pretty sensitive information, and I think are just not, I know Katya has made some points about, in BOP custody you can't get it, but I think just in general, it's not like a public document that's on the record. I think that there is a lot of pretty sensitive information. And so we had kind of discussed in a working group whether this is something that's appropriate for kind of dissemination more broadly. So like I said, I was just kind of flagging that. I think that they're, you know, if a person is in BOP and kind of representing themselves, I think it obviously works a little differently in the clemency board situation where you don't necessarily have a lawyer who can keep it for you and talk to you about it. But I am not a defense attorney, so I totally defer to other people on that. But yeah, I think that there's some concerns with kind of a more broad dissemination of the pre-sentence report.
And we added that information here, I think, at our last meeting. Let's see if I. That all information obtained through the board's background retrieval process will be protected according to the handling instructions of the releasing agency.
Right, but if we're not allowed to give it to anyone in custody and they are representing themselves, it's kind of an awkward situation to be in for them, I would expect. I mean, they might have seen it 30 years ago when they were sentenced or whenever it was.
I think certainly just being aware that that would be something we would hold close with us and check in with CISO so as we go along the process. But I think for our evaluation purposes, we need access to it, and we will have access to it. Any with that issue flagged and what we just covered about the completeness and eligibility worksheet, I didn't know if any board members had additional questions with respect to Appendix A or additional things we should consider. All right, if there are no questions, didn't know if we wanted to take questions from the board, Patrick. I mean, from the public, Patrick.
Yes, please.
I don't see Professor Moyd on anymore. Oh, no, I still see her. Professor Moyd, any questions?
No, thank you.
Okay. And I don't believe the gentleman who's also a member of the public is on the call anymore. So no more questions.
Okay,
All right,
great.
Patrick, turn it over to you.
Thank you. So a few meetings ago, I think two months ago, we assigned board members a list of organizations to reach out to educate them about the Clemency Board and our process. I'll now do just a quick round robin of board members to, if you have any information that you could provide in terms of an update of how your outreach efforts went, we'd like to hear those and whether they have any feedback from the community based on those efforts. So I welcome the board to jump in if you have something to add around your outreach. I know it seems like a long time ago.
This is Lisa. Right now, I don't have any update about my outreach. I've sent some emails. I got to follow up with some phone calls, but I haven't been able to get in contact with the agencies that I need to get in contact with.
Okay, thank you.
I had a meeting with Free Minds executive director and spoke about the clemency board and the process, and she's going to disseminate the information to members. And I've been sort of scheduling back and forth with LaShanya Thompson-El about meeting, and I was away, and then we just had some scheduling stuff. So I think that that it will happen, but there's some further limitations on just scheduling. But I think I'll get it done hopefully before the next meeting.
Great, thanks for that. Others? Emily, Alana?
I think this is Emily. I think my only assigned outreach, tell me if I'm wrong about this, was CJCC. And Patrick, you came and did a presentation to the CJCC. That's the Criminal Justice Coordinating Committee. And about sort of where we are so far. And I thought it went well. I think the overall feedback we received is that they were very happy to hear we were moving forward and are interested in hearing about how they can help and support the work.
Right. And there was a follow-up during that meeting with the Victims Assistance Network, and I think we're scheduled to see them sometime in October. Am I right?
That's correct, yes.
Great.
And then on my end, I was able to meet with the Mayor's Office of Returning Citizens Affairs and CIC, Ms. Marks, and both were very interested in receiving our pamphlet, which I am working on getting edits to that were sent by Sonia a couple months ago. So, but they're really excited. They really like the pamphlet. They think it's a great idea. And so I'm just working on getting that printed and sent to them so they can get it in BOP facilities.
Great. Okay, if there's no other comments about the community feedback, we have no public here to comment. I don't think so. What I was hoping to do was to talk about our next meeting, which I'm going to propose either. I know August is a time for many folks to be out of the office. I didn't know whether there would be availability of at least 5 of us for Friday, August 5th at 10 a.m. The backup would be August 12th at 10 a.m. But is there anyone who's not available on Friday, August 5th at 10?
That's fine for me.
Alana,
I'm not available.
you're not? Okay,
Actually, both of those dates are bad for me.
both are.
Yeah.
Okay. If we went to the Thursday, August 4th, is a Thursday any better for folks?
Yeah, I could make that work.
10 a.m.?
August 4th works for me. This is Felisa.
Okay, 1, 2, 3,
Me too, Zelana.
4. Okay,
It works for me as well. This is Emily.
fantastic. So we're going to go with Thursday, August 4th at 10 a.m. And just to clarify, that meeting will principally be around making the final vote on this set of documents that we reviewed today, finalized today. So, Christina, can you tell us when will we see these documents in the final form that we're going to vote on?
Sure, I will consider all of the edits and comments that we received. I'll clean it up and send it back. I think ultimately just need recommendations from the board about those factors. Would you want me to keep everything in as it is now or clean it up and keep it more broad? I don't think we reached resolution on that.
Oh, I thought we did, and maybe I'm mistaken, but I thought we were pretty much consistent with the broad general ones, plus the DOJ stuff, plus the 3 or 4 that we specifically mentioned.
Okay. Then I will clean it up as such and send back to the board for review. I just want to highlight at our next meeting, we might have to have a closed session meeting. In addition to the consideration of the operating guidelines, we did receive an application. Yay. We are reviewing that now for completeness and eligibility, hence the importance of having our operating guidelines in some working order. And so for right now, I will continue to review for completeness and eligibility, and hopefully we have guidelines that are finalized next month.
Fantastic. So we're moving.
Yes.
So next board meeting, I think we're done with much of this administrative startup stuff. Put it to bed, right? That's fantastic. And now we have an application. We have the real work. So buckle up. Here we go. We're starting. It's great. Thank you, everybody, for the. I know, right? Finally. So thank you all for participating and for going longer today. I appreciate that very much. And I'm really looking forward to our next meeting where we go into a real discussion about an application as well. So thank you, everyone. Hope you have a good month.
Thank you, everyone. Thank you.
Okay, so we have to make a motion to adjourn.
Yes.
Anybody make a motion?
I'll make a motion to adjourn.
Thank you. Second.
I second.
All those in favor? Aye.
Aye.
All right, we're adjourned. Thank you, everyone.
Thank you. All right. Bye.
Bye now.